From broker duties to buyer performance disclosure. In the previous section, we discussed how brokers have fiduciary duties to disclose material facts and guide their clients through a transaction. Now we take that concept further by examining one of the most important Arizona cases defining a buyer's duty to disclose and the broker's role in that disclosure. This case reshapes a common misunderstanding in real estate: what information is considered confidential and what must be disclosed. The Lombardo case: why it matters. The Arizona Supreme Court addressed these issues in Lombardo versus Albu, a case involving a failed transaction and a buyer who could not perform. At the center of the case was a key question: does a buyer and the buyer's broker have a duty to disclose financial issues that may prevent closing? The lower courts initially said no, treating financial information as confidential. However, the Arizona Supreme Court disagreed and changed how this issue is understood in Arizona real estate practice. The facts behind the case. The sellers were under financial pressure and needed to sell their home to avoid foreclosure. The buyers, represented by a broker, submitted an offer based on the wife's ability to obtain financing, even though there were known financial concerns. The buyer's broker did not disclose these concerns to the seller. The transaction moved forward, extensions were granted, and ultimately the buyers failed to close, resulting in foreclosure. The lawsuit and legal issue. The sellers sued, arguing that they would have structured the deal differently or continued marketing the property if they had known about the buyer's financial instability. The core issue became whether the buyer's broker had a duty to disclose information about the buyer's ability to perform. The Supreme Court's key holding. The Arizona Supreme Court made a critical ruling. A buyer's financial ability to perform is not confidential when it is material to the transaction. This means that if a buyer knows there is a significant risk they cannot close, that information must be disclosed. Because the buyer has this duty, the buyer's broker shares that same obligation. Good faith and fair dealing. The court emphasized that all parties in a real estate transaction are bound by the duty of good faith and fair dealing. A buyer cannot present themselves as a ready, willing, and able purchaser if they know there is a strong likelihood the transaction will fail. Doing so is not just poor practice, it is a violation of legal obligations tied to the contract. The broker's role in disclosure. The court went further by clarifying that brokers cannot hide behind claims of confidentiality when it comes to material facts. If a broker is aware of circumstances that make it unlikely the buyer can perform, failing to disclose that information can create liability. This reinforces a key theme from earlier sections. Brokers are not just facilitators. They are responsible for ensuring transparency in the transaction. Confidentiality versus material facts. One of the most important takeaways from this case is the distinction between confidential information and material information. While brokers must protect client confidentiality, that duty does not extend to concealing facts that are critical to the transaction. If information directly impacts the ability to close, it moves from confidential to material and must be disclosed. Commissioner's rules. An unanswered question. The court was also asked whether a violation of ADRI Commissioner's rules automatically creates civil liability. The court declined to answer that question directly. Instead, it focused on the fact that the rules reflect existing common law duties, which already establish the standard of conduct. This means that even without addressing the rule itself, the obligation to disclose still exists. Practical application for 2026. Buyers must be informed that they have a duty to disclose any facts that could impact their ability to close. This includes financing issues, employment concerns, or reliance on the sale of another property. Buyers should obtain a conditional loan approval and understand the conditions tied to their financing before submitting an offer. If circumstances change during escrow, those changes must be communicated immediately. Broker best practices. Brokers should ensure they are working with qualified, ready, and able buyers. If there are concerns about a buyer's ability to perform, those concerns must be addressed early, not ignored. If financing falls through, the broker should obtain proper documentation, such as a loan denial, and communicate appropriately with all parties. Transparency early in the transaction prevents disputes later. Bringing it all together. This section builds directly on everything we have covered so far. Advertising taught us how to present information. Disclosure taught us what must be revealed. Broker duties showed us how to guide clients. Lombardo now clarifies that performance itself is a material fact that must be disclosed. Real estate transactions rely on trust, and trust is built on accurate and complete information. The most successful agents understand that protecting the transaction means ensuring that all parties are honest about their ability to perform. Online discussion question: why did the Arizona Supreme Court determine that a buyer's financial ability is not confidential? Answer: because it is a material fact that directly impacts the buyer's ability to complete the transaction and must be disclosed to ensure fairness. Question: how does the Lombardo case impact a buyer's broker in real estate transactions? Answer: it establishes that the buyer's broker shares the responsibility to disclose information that could affect the buyer's ability to perform. Question: what is the key difference between confidential information and material information? Answer: confidential information is protected unless it becomes material to the transaction, at which point it must be disclosed.